Welcome, friends, to today's Lawrence Center event. My name is Michael Chan, and I am the Executive Director for Faith and Learning here at Concordia College. Overseeing the Lawrence Center is one of my cherished responsibilities. The center honors the life, work, and legacy of Norman M. Lawrenson, renowned philanthropist, former CEO of Burlington Northern, alumnus of Concordia College, and former member and chair of its Board of Regents. Through his life and generosity, Norm helped to build a joyful, just, and more trustworthy world. In honor of that legacy, the Lawrence Center takes up the question, how do we build a more trustworthy world? In today's conversation, we will feature the voice and work of another builder, Nadine Strossen. Throughout her career as a lawyer, advocate, and leader, she has been building a case for free speech. We will now hear some additional comment about her remarkable life and career from Concordia pre-law student, Kipton Jensen.
Good afternoon. My name is Kipton Jensen, and I'm one of the founding members of the Pre-Law Society at Concordia and a member of the PLS Leadership Council. On behalf of the Pre-Law Society and the Lawrence Center, I would like to introduce our guest. Regarded as one of America's 100 most influential lawyers, named one of the country's most influential women, Professor Nadine Strossen is a prominent figure in the free speech debate, advocating for the protection of speech under the First Amendment of the U.S. Constitution. As a leading expert on constitutional law and civil liberties, Professor Strossen has testified before Congress on multiple occasions and serves on the advisory boards of the American Civil Liberties Union, Academic Freedom Alliance, Heterodox Academy, and the National Coalition Against Censorship. She is a chaired professor emerita at New York Law School and was the national president of the American Civil Liberties Union from 1991 to 2008. She is currently a senior fellow at FIRE, Foundation for Individual Rights and Expression. Professor Strossen graduated magna cum laude from Harvard Law School in 1975, practiced law in her hometown of Minneapolis as well as New York City before becoming a law professor. In 1995, she published Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights, which was named a notable book of 1995 by the New York Times Book Review. More recently, she published a book titled Hate, Why We Should Resist It with Free Speech, Not Censorship, which has been widely praised by ideologically diverse experts. Finally, Professor Strossen, I would like to extend gratitude on behalf of Concordia College for sharing your time and wisdom with us today. Please join me in welcoming Nadine Strossen.
Thank you so much, Kipton.
And thank you so much. Welcome back to Minnesota, Nadine. How do you like the weather? It's been nice today, huh?
From inside, it's beautiful.
We are so delighted to have you here. We've been planning this event for months and have just so much looked forward to hearing your wisdom and some of your insights. Well, the way today's session is going to work is we're going to do about 25, 30 minutes of moderated Q&A right now with Nadine. We've got 3-4 questions to ask. And then we're going to open it up to the audience, both virtual and in person. And so if you already have questions about this topic, start jotting them down and run up to those microphones. We do want to make sure that we privilege our student voices most especially. And so actually our first question from the audience will come from one of our students. So here's question number 1, Nadine. It has to do with kind of the distinction between free speech culture and free speech law. Do you think that the quality of free speech culture is stronger or weaker in the U.S. now than when you first started working with the ACLU in the 90s and the 2000s? And maybe as a follow-up, how does the culture of free speech in the contemporary setting compare to the legal landscape around free speech?
Well, thank you so much, Michael. Thanks to the president, faculty members, including Eric, students. I'm so impressed by the students I've met and the faculty I've met. It's just a wonderful, wonderful environment. And thank you for your commitment to free speech, because as I said in Eric's class, I think the single greatest threat to free speech is lack of public understanding. And clearly, you're making great efforts to avoid that here. But that ties directly into your excellent question, Michael. When people ask me about the state of free speech, I like to start by quoting the famous opening line in The Tale of Two Cities by Charles Dickens. Remember, it was the best of times, it was the worst of times. And in terms of free speech law, what we talked about in your excellent class just within the past hour, the law has never been stronger. What's so interesting is everybody knows we have a Supreme Court that is deeply divided on so many constitutional law issues, but on the most controversial free speech issues involving speech that substantial percentages of the public want to censor, such as hate speech or extremist speech or pornography, the justices are pretty unanimous in holding that it should be protected. So the law is very strong, but we do not exercise and enjoy meaningful free speech rights if we are afraid not of government punishment, government censorship, but rather intimidation, isolation, stigmatization, shaming, shunning, in a word, canceling. And I saw the slide presentation that Eric made about a survey he had done here, which is completely typical of surveys of other campuses, and for that matter, the public at large, which shows, I'll stick with campus for the moment, that students, as well as faculty members, are engaging in massive self-censorship, not of the positive kind, right? The positive kind is when you trim your words so that the answer is relevant, you're using professional and respectful language. But negative self-censorship is when you do not express an idea, or you do not even address an entire topic for fear that you might be accused of unwittingly having said something that is perceived as insensitive. And we have substantial numbers of people, both in your survey and in campus surveys around the country at institutions of every kind, from the Ivy League universities to Big Ten universities to small liberal arts colleges, public, private, secular, religious, you name it. All across the ideological spectrum, students are saying we dare not talk about the most important subjects, race and gender and immigration and criminal justice issues, for fear of offending and being punished by, not by our faculty members. And I think we have to pat ourselves on the back, because students all over the country are saying, no, our faculty members are treating us fairly. Even if they may disagree with what we're saying, what they're afraid of is peer pressure, that they're going to be isolated and stigmatized by their peers. And, you know, if government still does violate free speech, but the ACLU, FIRE, other organizations can readily go to court and win victories under the First Amendment. There is no First Amendment remedy to the problem of cancel culture, right? Cultural problems can only be solved through much more painstaking approaches, starting with education.
Well, that's my cue then, I guess. Okay. So, Nadine, I want to give voice, no matter my own political perspective, to students that may be very skeptical of either your political program in general or your principled defense of not censoring hate speech. And I'm sure that you have an answer, too. What would you say to a student who comes to you and says, Dr. Strossen, you are interested in making sure that people have the right to say and do things that make me unsafe. You are saying that you don't mind that other people are waiting in the wings to harm me this way. Why are you doing that? And why should I be sympathetic to a program that I perceive would harm me?
Eric, I am so happy that you've been candid with me about your concerns and that you're giving me the opportunity to listen to you and to learn from you. And I look forward to a continuing conversation because I completely share your concern about being fully included, respected, empowered, not only as an equal, but with a full dignity and a full voice in our community. I am completely committed to human rights and to education. And I want to tell you, the title of my book is Hate, Why We Should Resist It with Free Speech, Not Censorship. And notice that the only verb in the title of that book is resist. My overall goal is to resist hatred and discrimination and stereotyping and to promote equality and dignity and inclusivity and societal harmony. So, we're in this together, and I want to do everything I can to ensure that your full dignity and participation is respected. Now, I think that, first of all, I want to say that, any harm in the sense of physical violence or threats of physical violence or speech that is imminently likely to threaten violence is completely unprotected. And I will do my best to ensure that the laws against that kind of violent conduct and intimidating and otherwise unlawful speech will be enforced. Beyond that, though, if we empower government officials to have a looser definition of speech that might lead somebody to engage in harmful conduct, I'm afraid that that is actually going to do you more harm than good because that is a tool that can be used to suppress ideas that you have that other people will say are harmful to them. So I think I think we can agree on what the goals are, and hopefully we can agree on enforcing laws against discriminatory or violent conduct. Hopefully we can agree on the laws that allow intimidating speech, threatening speech, inciting speech, bullying, harassment. All of those are unprotected. Hate crimes, if somebody singles you out for an assault and, utters epithets in the process of doing that, they can probably be punished as a hate crime. So we have a lot of speech that is probably the kind that you're most concerned about is actually already unprotected. And then we can talk about, the pros and cons of going beyond that. Is that okay?
Yes, I think that would be very convincing to me. If I could follow up then, I guess, with a more scholarly point, I am genuinely curious to know your answer to, I guess just a question to follow up on that. Let's imagine, say, that we could draw hate speech restrictions so narrowly that they really did only outlaw the kinds of speech associated with the kinds of political programs that they're intended to. White supremacism, Nazism. Let's imagine that we could narrowly tailor that law just perfectly. You still wouldn't want that law.
I would only want the law not drawn on the basis of the content of the speech. So the problem is not, let's assume that a law was only going to be enforced against discriminatory, hateful ideology. I still would not want to empower the government to punish it solely because of disagreement with or disapproval of the idea. That's distinct from the categories that I did describe, where it goes beyond solely disapproval of the ideas to an independent harm that is imminently or immediately triggered by the speech, such as inciting violence, harrying you, interfering with your freedom and privacy, threatening you, making you fear that you're going to be subject to an attack. And the reason is that censoring the idea is not going to make censoring the expression is not going to make the idea go away. Let me back up. The problem from my perspective are attitudes and actions. Expression is just a superficial manifestation of deep-seated ideas. Putting somebody in prison is not going to persuade them to abandon their hateful ideology. In fact, we know that, they're likely to have those ideas hardened and become members of supremacist gangs in prison. It's also really important that we focus on actual discriminatory conduct. And here I have to pat the United States, give the United States a lot of credit. Obviously, I spend full time as a critic, hopefully a constructive critic. I love the ideals on which this country was founded, and we're moving closer and closer to honoring them in reality. And one of the things that we have done very well that other countries have done much less well is actually outlawing discriminatory conduct and enforcing those laws. We started passing anti-discrimination laws in the 1940s. Of course, in the 1960s, we got them at a federal level. Now, take a country like Germany, which has a certain history of hateful and discriminatory conduct and violence, including mass murder, not to mention hateful speech. Germany has been in the foreground of outlawing hate speech, including anti-Semitic speech, including during the period when the Nazis rose to power. Guess when Germany enacted its first anti-discrimination law? The very first time that it outlawed racial discrimination in employment, housing, public accommodations. If you guess any time before 2008, you are wrong. And the only reason that Germany finally passed an actual anti-discrimination law then was because the EU, the European Union, insisted on it, imposed a deadline. Germany missed the deadline. The EU had to bring a lawsuit. And I think this is no coincidence. When people and politicians focus on censoring speech, it's a distraction from doing the much harder work of going after, trying to change the attitudes. That's the cultural, educational problem, which we're all engaged in here, but also outlawing the actual discriminatory and violent conduct. And that was the problem during the Weimar Republic. So Nazis were prosecuted for engaging in hate speech, and they did serve time. And they loved it. They used it as propaganda platforms to gain attention and sympathy. The problem was that they literally got away with murder. They were not punished for beating up, assaulting, and actually killing Jews and communists and other political opponents.
I wonder, just a follow-up to that, the language of harm, there's been kind of significant, I'd say, kind of concept creep is one way of talking, or definitional creep around the term, and especially the idea that speech is harm. So I've heard you in a number of kind of podcasts and other settings speak about this. What are your thoughts on some of the concept creep there, how it helps or hinders a kind of promotion of a more free speech oriented environment?
Speech definitely can cause harm. There is no doubt about that. And I completely agree with the Supreme Court when it said that the reason that we protect speech so strongly is precisely because speech is so powerful. And it's a power that can do a great deal of harm as well as a great deal of good. Now, the question, and in fact, one of the epigrams to my hate speech book is from a famous early 20th century free speech expert at Harvard Law School, Zechariah Chafee, who said it, this is a paraphrase, the ultimate problem in every free speech case is this: how close a connection does there have to be between the speech and harm before we can punish it? Oliver Wendell Holmes, famous Supreme Court justice, said every idea is an incitement, right? Every idea might stimulate a certain action. That action might be harmful. And he didn't say that as a justification for punishing every idea. Obviously, it was exactly the opposite, that potential harm is not enough. There has to be such a tight and direct causal connection between the speech and imminent harm. And I already gave a few examples where the law already allows that to be punished. If we allow government latitude to restrict harm that has a more indirect, speculative connection to speech, that's what we used to have before the mid 20th century, and the Supreme Court used the term bad tendency. Speech that had a bad tendency that might possibly, at some indefinite future time, lead to some harm. That gives so much discretion to whoever is enforcing the standard that basically they can pick and choose ideas they don't like, speakers they don't like. And under that looser concept of harm, that potential harm that was sufficient to justify punishing speech, that is why Martin Luther King wrote his famous letter from a Birmingham jail. Everybody knows that he wrote that letter from jail. Most people don't know what was the crime. What was he doing in jail? His crime was to try to exercise what we now consider the most fundamental free speech right, namely to protest government injustice. And until the Supreme Court strongly protected free speech, that was considered a crime. And that was the same fate that befell women's suffragist advocates, abolitionist advocates, labor organizers, pacifists, anti-war demonstrators, certainly socialists, communists, everybody to the left of center. So yes, speech that is not sufficiently directly connected to harm can itself, to be punished, can ultimately potentially lead to harm. But I think the greater harm is giving the government the additional power and discretion to punish speech with that looser connection.
Okay, last thing, or I guess second to last thing that we wanted to ask you about before opening it up to student questions. As I'm sure you're aware, there was a very prominent story out of Hamline University recently that made national news regarding the dismissal of an adjunct professor who had shown an artistic and devout depiction of the Prophet Muhammad in their class. And I'm wondering if you could just comment on how you see that case and maybe some of its subtleties and complexities that we might not appreciate.
I don't think it was subtle or complex at all, to be quite frank. I think I agree with the assessment of PEN America, FIRE, the National Coalition Against Censorship, basically every free speech, academic freedom organization in the country. And by the way, a number of Muslim organizations, as well as Muslim intellectuals, saying this is one of the most blatant violations of academic freedom in recent history on a number of counts. I mean, the professor, I thought, handled it so responsibly. She gave trigger warnings in advance. I mean, she knew that certain Muslims, certainly not all, do see it as a violation of their understanding of their faith to depict or to look at a depiction of the prophet, but certainly not all, as demonstrated by the fact that this was a painting that was painted by a Muslim artist for a Muslim official, king, I believe, some royalty, that was reverential, that was showing respect toward the Prophet Muhammad. Anyway, she gave the opportunity for students not to see it, both in writing in advance and immediately before showing it in that class session. It was pedagogically very relevant. It is a very respected work of art. And interestingly enough, part of her goal was part of what's called the decolonization. You know, back in the ancient days when I studied art history, it was all, you know, Western art. And there was something really not appropriate about that. We do want to celebrate great Islamic art from the medieval world. Now, a friend of mine who's a professor of history at Carleton College and a Muslim, Amna Khalid, wrote an op-ed in the Chronicle of Higher Education, and the title of it was I Am Offended as a Muslim. And she talked from her own perspective and that of many other Muslims about how important this piece was, how important intellectual freedom is, especially to minority religions, including hers. And what more can I say? There was also a violation of due process because the professor was summarily fired, maybe too strong a word, because she was an adjunct and didn't have tenure, but she was not given an opportunity to defend herself. And to add insult to injury, one of her colleagues in the art history department at Hamlin wrote a very lengthy defense of her pedagogical decision, of the importance of the art, of the appropriateness of the trigger warnings. And it was originally published in the student newspaper, but then the student newspaper took it down. So there was a censorship of the defense as well. Let me say this, the faculty signed a petition calling for the dismissal of the president who was the one who issued very punitive sounding statements and actually literally said preserving students' feelings is more important than academic freedom. And one of my friends, who's another friend who writes op-eds, Jonathan Zimmerman, who teaches at University of Pennsylvania, had an op-ed, I think also in the Chronicle, in which he said, now let's not be so punitive toward the president. And I thought that was very gracious. He said, you know, she made a mistake from our perspective, but let's not drive her out. Let's use this as an opportunity for education toward her as well as toward everybody else.
Yeah, thanks, Nadine. Just one last question, and then we're going to open it up to our questions from the audience. This has to do with a Supreme Court case, 21476 303 Creative LLC versus Ellenis, and
Very memorable name, right?
yeah, especially the 476. Can't forget that. So let me offer a little bit of preface in in kind of a naive way, and then you can correct whatever errors I might make. But this, there's a woman who owns 303 Creative, and she builds websites. And she decided that she wanted to put a kind of disclaimer, a notice on her website saying that she would not build websites that specifically are in support of LGBTQ marriages or same-sex marriages. This was in opposition to Colorado state law that was revised in 2008, I believe. And this case, I think, really puts into focus some of the tensions that I think many people feel. Because on the one hand, her lawyers are framing this as a conscience rights kind of thing, a free speech kind of case. I think Colorado sees this as discrimination. And so it really focuses, I think, some of the tensions around the free speech argument. And the ACL, I think you and the ACLU actually parted, or you had different opinions on how to think about this. So help us bring some clarity to that.
Yeah, so the devil is in the details, right? Very specific, factual aspects of this case that I think aren't as well known publicly as they should be really affect my analysis because I want to maximally protect all of the rights that are at stake. Of course, the right to full and equal dignity and participation in the public sphere and access to public services by anybody, regardless of who they are, including gender identity and sexual orientation. And also, I'm not saying but also, and also the right of all of us, including all of us of whatever sexual orientation or gender identity, to be free from government-compelled expression. The government may not put words in our mouths that violate our own beliefs, whether they're religious beliefs or whether they're secular beliefs. And let me tell you, the very first case in which the Supreme Court recognized this really important right was an ACLU case. I'm very proud to say one of the greatest decisions the Supreme Court has ever issued in 1943, called West Virginia Board of Education versus Barnett. That was a case that arose during World War II when, in a fervor of patriotism, states passed laws mandating that public school children salute the American flag at the beginning of every school day. And if they didn't, they could be expelled. There was students who belonged to the Jehovah's Witnesses faith had a conscientious, religiously based objection to this mandatory flag salute. It violated their interpretation of the Second Commandment against saluting graven images. And at great personal price, these students and their parents refused to salute the flag. They were horribly punished, subject to beating, antiquated punishments that we don't do anymore, tarring and feathering. I remember that from Tom Sawyer, forced to swallow castor oil. One member of the Jehovah's Witnesses was even castrated. I mean, it was just horrible. And the Supreme Court, in a very eloquent opinion, that went way beyond the religious beliefs, that went way beyond school children, said that government may never compel any of us to voice anything in the realm of faith, politics, any matter that is inconsistent with our own conscience. And the Supreme Court said that it is even more of an offense to individual liberty to be forced to express something that is inconsistent with our own beliefs than to be stopped from saying something, that there would be no exceptions at all to compulsory expression. So in a prior case, in this line of cases that went to the Supreme Court, people call it the cake case, the big debate was over, well, is that expression to be forced to bake a cake for a same-sex wedding? And I completely agree. That was actually an ACLU case. I agree with the ACLU that baking a cake is providing a service. It's not compelled expression. I would have defended somebody from saying, I'm not going to put a message on the cake for anybody that violates my conscience, but being forced to bake a cake is not expressive enough. Now, I'm sorry to go into so much detail, but the facts really matter. They make, all First Amendment cases are very fact-specific. And in this case, the government of Colorado entered into what we lawyers call a stipulation of fact with the website designer, and they agreed that every single website voices her creative, artistic expression. They also agreed, and there's nothing in the record to contradict this, that she will never discriminate on the basis of who you are. She will provide every service to everybody, except she will be selective on the basis of messages. So no matter who you are, there are certain messages that she won't put on the website, including not only messages celebrating same-sex marriage, which is against her religious beliefs, but also discriminatory messages. So interestingly enough, if you came to her and you wanted, you're a white supremacist organization, or you're an organization that advocates, doesn't support equality on the basis of sexual orientation or gender identity, she's not going to put that message up either. So I think the ramifications here are really powerful for those of us who care about free speech. And I want to say, because, the ACLU was filing a brief on the other side, and I don't have enough of the courage of, I should say I don't have enough arrogance that I'm going to forge ahead on my own. So I asked two of my best friends, are people who have been in the forefront of advocating for same-sex marriage. And the students here are so young, you're not going to know this history, but now that has such great support, but that is just a sea change in really very, very recent history. So you probably all know that Barack Obama opposed it, Hillary Clinton opposed it, and much of the, I should say most of the gay rights movement opposed advocating for same-sex marriage as the ACLU did for many decades because they saw it as a fringe issue that would alienate the general public from what they saw as more core, urgent issues such as, decriminalizing same-sex relationships. So to make a long story short, two people who are as old as I am and who, gay men who have been crusading for the right of same-sex marriage equality, even when that was considered a fringe position, both of them filed briefs in support of the website designer, in this case, stressing that robust freedom of speech has been especially important for advocates of LGBTQ rights at a time when there were no other rights. The First Amendment for speech that was extremely controversial is what ultimately allowed that movement to thrive and succeed as far as it has.
Yeah, thank you so much for those additional details. What we're going to do now is invite up one of our courageous students, Rebecca Lawatch. And Rebecca has graciously agreed to kind of kick off the Q&A time with the first question. Rebecca, it's to you.
Hi, Dr. Strossen. My question is, the rise of the internet over the last several decades has changed the landscape of free speech through the wealth of information available. Ideas can easily be self-published and distributed in mere minutes through social media platforms and websites. To what extent, if at all, does this change the way that we talk about and handle free speech today? Should it have any sort of impact on future legislation and decisions and or responses and attitudes surrounding the exercise of the First Amendment by our society?
Thank you so much, Rebecca. Very important question, which arises every time a new communications medium is invented or comes to public attention. And throughout history, certainly going back to the printing press, every time there is a new communications mechanism that makes it easier and cheaper and faster for more people to communicate with more people. Some of us get very excited about the positive potential of that new technology, and others get very nervous because, going back to earlier discussions, speech can do a great deal of harm as well as a great deal of good. And I think that we had probably an initial excessive exuberance about the internet, but now the pendulum has swung too far in the opposite direction, where people tend to be disproportionately focusing only on the negative aspects. So again, recalling when the internet first burst upon the public and political radar screen in the 90s, early 90s, I want to remind these much younger students who have taken its power for granted, please do not. I mean, I think of all of the looking at the issues that are important to me, social justice and human rights causes that had existed before but never really took off until we had the power of the internet and social media to make it much easier to organize. So, the Black Lives Matter movement had existed, but it really only became galvanized with the power of social media. Obviously, I hope it's obvious that, forever throughout my entire lifetime, we were crusading against sexual harassment and sexual violence. But, thanks to the power of social media, the Me Too movement finally got traction. Obama's campaign was, I think, the first that was given credit for making great use of social media. He was a relatively unknown candidate who made great use of that. And now you see it at state and local election levels all over the country, that especially candidates, women candidates, candidates from minority, ethnic, religious, racial backgrounds, those who don't have access to the huge amounts of money that you need for traditional advertising over the broadcast media are really able to use this much cheaper method of reaching potential voters. And so it's had a really positive impact on the inclusiveness and equality rights in our democracy. Obviously, there are problems, Rebecca, and we can use some of the same tools that we've used to deal with problematic speech in other media.
Thank you so much. No, so the microphone will be here, please. If you like, you can line up behind it or else sit here at the front table. We do have some online questions as well, so I think I'll feed one of those to you now while we wait to see if there's someone here in the in-person audience. So this question goes as follows. A columnist in the Forum, one of our local papers today, wrote a column about Americans' distrust of government, noting that there is a simultaneous desire to use it by some to restrict speech of those with whom one disagrees. Do you have any insight to add to this observation?
Can you repeat that? I'm so
You
sorry.
bet, no problem. There was a column written today about Americans distrusting government. And yet there's also a desire by some to entrust that government with the power to restrict the speech of others.
I think it's a great question, which it's a rhetorical question, right? And it comes back to a point that I made earlier. Free speech is certainly can do a lot of harm as well as a lot of good. But the question is, as compared to what? As compared to government control, as compared to entrusting, powerful gatekeepers in the private sector to make these determinations. It makes me think of that famous aphorism by Winston Churchill. I'm sure you've all heard that democracy is the worst form of government except for all of the others. And as a civil libertarian, I do have a healthy distrust of government. I think excessive distrust becomes problematic because we need a certain basic trust in order for our participatory democracy to thrive. On the other hand, we also need a healthy skepticism toward government officials to hold them accountable to we the people and to protecting and respecting our rights. So I would, people are very skeptical when I say I trust my fellow citizens, and I use citizens in the sense of members of the community, to use their own judgment about what to believe and what not to believe. And people say, oh, but, people are so naive and they believe disinformation and they believe fake news. But the point is, I would rather trust my fellow citizens than trust the government to take away from us our power, our right, and our responsibility to make wise choices about what we read, what we don't, what we believe, what we don't.
Thank you. Is there someone here from the audience who'd like to offer a question? We do have some more online ones. I just want to make sure, especially that our students have a chance to pose a question. Please, come on up to the mic. And make sure to speak into it really clearly so that our online folks can hear you. Thank you so much.
Thank you for the opportunity. In one of our classes, we talk about the rights and the freedoms that student journalists have in terms of freedom of speech and expression. So, have the courts provided schools and students with a useful set of guidelines for identifying the limits of student speech rights? And two, should students possess the same First Amendment rights as adults? Thank you. My name is Andy.
Andy. Well, so students are adults, right? And that's a great question. And the U.S. Supreme Court, in a series of cases that have been brought by the ACLU, I'm proud to say, has strongly protected students' free speech rights, going back to that 1943 case that I mentioned, and that involved students, grade school students. Now you specifically ask about student journalists. So let me answer the general question and then I'll get to journalists in particular. The Supreme Court's most recent case about students' free speech rights was decided in 2021. Some of you may remember reading about the case. It was called the case of the cussing cheerleader. Brandy Levy was a cheerleader. She wanted to be a cheerleader. She wasn't accepted to the varsity squad, and so she used Snapchat on her phone on a weekend at a convenience store to send a message to her friends in which she just used the F-bomb over and over again, you know, F the school, F the coach, F the whole world, you know. And the school suspended her for quite a few days. The ACLU came to her defense, and I'm very happy that the U.S. Supreme Court held in very strong language that the school had no power to punish her for her personal speech on her own time, on her own piece of equipment, to her own friends, even though it was a message that involved the school, even though they argued that, you know, it undermined the morale of the coach and others who were insulted. And they basically said she had the same free speech rights as the rest of us do to criticize public officials. And that's, after all, what public school teachers and coaches are. And there was very strong language in which, to your point, about, you know, that far from saying that students have fewer free speech rights, the court said it's especially important to protect their free speech rights because, and this is an exact quote, our schools are the nurseries of our democracy. This is where we are educating those who are going to hold the sovereign power as citizens. And how can they responsibly do that unless we maximally protect and respect their free speech rights? Now, I think you said your name was Andy. Andy, as to student journalists, you probably know this. I suspect that's why you asked me. There was one terrible Supreme Court decision in 1986. It was also an ACLU case, and I like to say, you know, the ACLU always has truth and justice on our side, and we have great lawyers, so we never actually lose a case, but sometimes the court makes a mistake, and this was a mistake. You know, not as bad a mistake as it could have been, but basically, it was a case involving a high school newspaper in which the principal censored, I mean, literally cut out 2 articles that he considered to be controversial. One was about students who were pregnant, and another one was about students whose parents were getting divorced. And he just thought, you know, these are too sensitive and too controversial. We don't want them. And the Supreme Court held that that speech, the student newspaper, should be seen as the expression of the school itself and not of the students, and therefore the school could decide what it wanted to put its imprimatur of approval on or not. I think as a factual matter that was wrong, but at least it's subject to damage control because schools that want to get around that could clearly designate that this is a student newspaper, have a disclaimer at the top saying this is not an official school publication, it is published at the direction and at the discretion of the students, and that would give the students and not the principal the editorial discretion in the future.
Let's turn to another online question, and this one will ask you to wade straight into presidential politics, so you're welcome. I, like perhaps many, can't help but think of the January 6th assault on the Capitol and the implications of the president's remarks just prior to the attack. I'm curious about your thoughts. Free to make the remarks, but absolutely punish the actions. So how do you think about that?
So your students would all know this. I could ask them. I see a table of them over there. It's the Brandenburg test, right? That the question, of course, anybody who engaged in violent or threatening, intimidating, assaulting conduct can be prosecuted, and they are being prosecuted, and many of them have already been convicted. The question is whether Trump or perhaps others can be held culpable for having incited the violent and lawless conduct. And as everybody over there knows, the standard was set out in 1969 unanimously. I'm sorry to keep saying this, but it was another ACLU case. I'm very proud of our track record. And the standard is that the speaker you cannot be punished merely for advocating violence or lawlessness, right? The court said that expressly. But here's what can be punished: intentionally inciting imminent violent or lawless conduct that is likely to actually happen imminently. A very hard but not impossible test to satisfy. And as with all of these other standards, very fact specific. And here, not all of the facts have come to light, but let me tell you a precedent. The Sixth Circuit Court of Appeals, which is immediately below the Supreme Court, decided a very similar case that came out of a Trump rally when he was first running for president in 2016. And you may remember this, the rallies are invitation only. You have no right to be there as a demonstrator. So there was a demonstrator, an anti-Trump demonstrator, and he had some, incendiary language to his supporters saying, get him out of here. And I think he said something like, in the old days, we would carry him out on a stretcher, and I'll pay your lawyer's fees. Very provocative language. And some of his supporters roughed up some of the counter demonstrators in the process of hustling them out of this rally. And they brought a lawsuit not only against the people who had physically intervened with them, but also against Trump himself. And it went to a judge and then to an appellate court. And the appellate court said, it's a very close case because there are a lot of things he said that can satisfy that standard. But on the other hand, at the end, he said, but don't hurt him. And the court said that tips the balance. And if you look at everything that Trump said on January 6th, you may remember he had a lot of incendiary statements, but he also said something like, but go in peace. And I think he's either very lucky or very well advised by a lawyer. So I think it probably is not going to be enough to satisfy that standard. But I can tell you, constitutional law professors have written op-eds one way and another.
Thanks for that response. Someone else from the room?
That would be another great exam question, Eric.
Yeah, Per, would you mind using the microphone? That would be great. Thank you so much.
Thanks so much, Professor Strossen. I taught religion at the college for several decades, so been in the middle of some of these tensions. And I want to ask for your reflections on this self-censorship that you see in the classroom and the cancel culture reality. And I want to refer to Yuval Levin's thought on this, who we had here in August. And he's got an interesting view of the American university as a place of tension between three cultures: professional development, moral activism, and then classical liberal arts, which is a free expression and critical search for truth, not just toleration of diverse points of view, but the unending search for truth that requires some suspension of one's own beliefs and things like that. And he goes on then to notice this reality of self-censorship, and then wants to criticize identity politics because he thinks it's lending itself to a view of the human life where we've got it all together. We don't need to hear the critical ideas of others. We don't need to be formed by the university. And it seems to me, if that's true, that's a very difficult reality for what we try to do in universities, to suspend beliefs, to imagine that we don't have the good life figured out, and we need each other in a critical engagement, which can be very painful at moments. And that's what we've turned to in places like Concordia would be a place where we say, everyone in this classroom is a human being. Maybe even we want to say a child of God. We want to begin with a certain kind of identity that is, we think, larger than one's political identity, and so on and so forth. But I think increasingly that just doesn't work in the current environment. I just wonder how you see the rise of this self-censorship, the causes of it, particularly on the cultural level. If the law can't address it, what are the cultures that can try to address that?
I completely agree with the assessment of the issue. It reminds me also very much of the writings of Jonathan Haidt, a social psychologist who teaches at NYU and was the founder of Heterodox Academy, who has really advocated very strongly that the university, it's a, I guess, a somewhat different perspective in that he says the university can have only one mission, which must be truth-seeking, and instead he sees universities as having adopted, often expressly, social justice activism as their mission. He said that's fine if they want to be social justice institutions, but that's not what the function of a university is, and he sees that mission as being at odds with the truth-seeking mission. Interestingly enough, having spent my entire adult life as both an educator in the university context and as a human rights crusader, I guess I've worn both hats, and I really do. I do try to fulfill different functions in those two different roles. I do see them as being distinct from each other. I would say that, you know, the focus on identity can be positive if it's not taken to an extreme. I guess that's true of everything. Again, I'm going to use this phrase, the devil or the angel is in the details. I think it's really important for each of us to celebrate every aspect of our identities that we choose to, whether it be our, you know, our ethnic or racial or religious or any other kind of background, whether it be our experience, whether it be our religious beliefs, our political beliefs, our philosophical beliefs. But you know, by virtue of the fact that I'm mentioning so many factors, I really chafe at the idea of trying to boil down any human being into one particular overriding identity. I think that does a disservice to each of us as an individual, both in who we are at the moment and certainly in stifling our ability to grow and to expand our horizons and to be able to learn from others. My friend Randy Kennedy, who's a professor at Harvard Law School, African-American, great advocate of civil rights, and he can get away with saying some things in his classes that I just would never say in mine. But when he says that too often students will precede their comments in class by saying, you know, as a white woman or as a Lutheran man or whatever, and he just stops it. He says, cut it. I don't want to hear what comes before the comma. That is completely irrelevant. I only care about the substance of what you're saying. Now, in fairness, I think we do want to recognize the fact that who you are in every way, in the fullness of all of the complex factors that make you who you are, and what your experience is, no doubt does feed into and inform your perspectives. But the purpose of an education is to help you surmount that, expand, go beyond it, to challenge that. So I hope I'm just complimenting the fine points that you made. With an I in compliment and with an E in compliment, both versions.
Thanks. We're approaching the 1 o'clock hour. I know some of you need to go. Professor Strossen has graciously agreed to extend our time another 10 minutes or so, and then she'll have another appointment. So if you need to go, don't feel bad about it. You can stand up and leave. But otherwise, we're going to continue on with the Q&A. We have a couple of other online questions, and then if those of you here in the in-person audience want to ask something, now would be a great time to do it while everybody else is standing up too. Okay, we'll go with an online question as a starter. Is there ever an appropriate role for the FBI or maybe law enforcement more generally to influence social media regardless of political impact?
To influence social media, I wish I could have a follow-up to clarify that question. The FBI has been in the news a lot lately. Let me take this as, you know, so to riff on the question, what role has the FBI been playing? According to the so-called Twitter files, I don't know how many people have been following that, but Elon Musk released a lot of the email communications from Twitter that showed that the FBI and the Department of Homeland Security and other law enforcement and national security agencies of the federal government have been working very closely with Twitter and then presumably with the other social media companies as well to very strongly influence decisions about what speech should be taken down as disinformation that might have adverse impacts on law enforcement and national security. And this is a very troubling development. Of course, any kind of voluntary cooperation or information that the FBI might want to share in the service of law and order and justice is fine. But when it starts to creep into pressure or coercion to take down communications that express dissenting viewpoints or unpopular political viewpoints, that becomes concerning. That is not a role that we want our law enforcement agencies to be playing. Even more disturbing is evidence that the CIA and agencies that are tasked with dealing only with international threats and are not supposed to have any power domestically. Again, you know, I'm not reaching a definitive conclusion because, again, more information is coming out every day. Congress held hearings on this last week. I haven't yet been able to read the transcript, but it's definitely a cause for concern worthy of investigation.
Eric, I wonder, do you have a question or something you might want to offer? I don't see anybody lining up for the microphone yet.
I do have a question. It might open up a can of worms, but I think it'll be an interesting way to potentially end. We've been talking a lot last night at dinner and this morning in my class on the First Amendment about the policies that public and private universities, including liberal arts institutions, have in place that may or may not be conducive to a free speech culture, let's say. If you could snap your fingers today and impose one policy change related to free speech on every college or university in the United States that you think would create a better free speech culture, what would it be?
Wow, that is such a great question, and nobody's ever asked it before. Um, I so this may be evading the question because I don't think the problem is the policies. Yes, there may be problematic policies, but let me put it this way. The best policies in the world are not going to make any difference if they are not enforced. So what, I mean, we have like, you know, I can name the very prestigious schools with, you know, absolutely top-notch free speech policies. They've adopted the Chicago free speech principles. They've gotten the green light, which is the best rating from FIRE. And yet the administrators, the so-called leaders, cave when there is a violation of free speech and don't enforce the policies, don't discipline those who have violated the policies. And so what I would want to do is to ensure that nobody is hired or retained or promoted as a president, a provost, a chancellor, a dean, any kind of leadership position without a demonstrated commitment and continuing commitment to actually upholding and enforcing the policies. You know, I have to tell you, I spoke at an academic freedom conference recently at Stanford University. And I think, you know, there are many, many speakers over a couple of days, but the single best line I thought was a law professor who had been subject to terrible retribution in violation of the policy of the law school in question, but the dean just ignored the policy. And this professor said, you know, he said, I have to disagree with you, a lot of you who are saying that the problem is that university presidents and law school deans are, woke activists. He said, that's not the problem. The problem is that they are spineless wimps. So that would be my change.
As you said, a can of worms, Eric.
Give them, give them a backbone.
We have maybe just a few minutes. Is there one other brief question from the audience that we can lift up, or are we in good shape? All right, Grace. Very good. Thank you.
I'm curious what gives you hope for the next years in terms of free speech.
You,
The free speech culture.
you and your classmates, and Michael and Eric and Bill and everybody here, and as I meet in my constant travels, not only on the campus lecture circuit, but I'm also tomorrow speaking at a high school and middle school, which I do very often. And I have to say, I also speak around the world because these are worldwide issues. On the one hand, I could say, looking at the glass half full, half empty, I could say, wow, free speech is so endangered that I'm constantly being invited to speak about it. But as an activist, I always see the glass half full, more than half full, and there is so much concern and so much interest. Not only are classes being taught about free speech. Students are forming free speech organizations spontaneously. A whole host of new organizations have been founded to promote free speech, specifically in academia. FIRE has recently expanded its mission even beyond campus to the world generally. A new organization I alluded to, Heterodox Academy, was founded about 7 years ago. The Academic Freedom Alliance a couple of years ago. And so, the pendulum is being pushed back. But we depend on all of you to keep pushing it back. So thank you for giving me hope and inspiration.
Nadine Strossen, thank you so much for your time. And just a few really brief announcements. Make sure that you go to lawrencencenter.com and subscribe there. We promise not to spam, fill your inbox with spam. We offer just a kind of weekly, bi-weekly newsletter that gives you updates on our programming. We'll send you the recording to this particular conversation if you want to share it with somebody. And we'll also give you information on future events. Our next event is going to be on March 30th, and it will feature Christine Emba of the Washington Post. And she's a really rising millennial African-American journalist who's doing some really interesting things in that space. So thank you again for joining us, and thanks for staying a little bit late. Thanks also to our online host. And Nadine, most especially thanks to you. Yeah. Yeah, Grace, what's up?